What happens when someone entrusted with over $80,000 in funds allegedly misuses that money? Today, we're diving into the case of State of Texas versus Ladonna Renee Lewis, a third-degree felony case that could land her up to 10 years in prison. But here's the twist. She's already paid back over $25,000, and the judge seems surprisingly sympathetic. Will her early restitution efforts save her from prison time? And what exactly does deferred probation mean for her future? Buckle up, because this case reveals how the justice system really works when money, trust, and second chances collide. Let's break down every crucial moment of this high-stakes courtroom drama.
101, the State of Texas versus Ladonna Renee Lewis. And you are here with your attorney, Mr. Nayland, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? In summary, this indictment alleges that on or about November 8th, 2020, is that a free? Yeah, 2023. 2023 in Jefferson County.
Hold up. Let's break down what misapplication of fiduciary property actually means. This isn't just theft. It's when someone who's been trusted with managing money or property uses it for unauthorized purposes. We're talking about $30,000 to $150,000 here, which automatically makes this a third-degree felony in Texas. That's serious business. The fact that she's facing up to 10 years in prison shows just how severely the law treats breach of financial trust. But here's what's interesting. The prosecution and defense have already worked out a deal. Let's see what they're proposing.
In Jefferson County, Texas, you committed the third-degree felony of misapplication of fiduciary or financial property of an amount more than $30,000, but less than $150,000. Do you understand what you're charged with?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Punishment range. The way we're getting all this changed, when you touch the pad with your hand, it makes marks on it. That's one of the, I don't know what has happened to all these things. They didn't used to do this, and now they're acting odd. An agreement's been reached.
You're just going, there's restitution, and then we're going to ask you to decide whether it's straight or deferred in the terms.
Okay. The agreement is she would be placed on probation.
Yes, sir. There's just no blank check that says just probation. So.
Okay, we need, because the way this reads, there's no consideration moving to make a contract here. It just says restitution, court to determine type of probation. Let's see.
Notice the confusion here? Even the judge is struggling with the paperwork. This highlights a crucial moment. They're negotiating between deferred probation and straight probation. Here's the key difference. With deferred probation, if she completes all terms successfully, the conviction gets wiped from her record. With straight probation, the conviction stays even if she completes probation perfectly. This single decision could impact her entire future, job prospects, housing applications, everything. The fact that they're leaving this massive decision up to the judge shows just how much is riding on his discretion.
Because one says deferred and one says after conviction placed on probation. There's no one that says court to determine type and length.
All right, I've got, the agreement is probation to be determined by the court. Restitution will be paid in the amount of $8,966.09. And then under just court to determine time, but it's under non-binding, but that's, let me change that. We're talking about community supervision here. Right?
Yes, sir.
Okay. And it's up to the judge to decide how many years? Is that what I'm gonna do?
It's whether or not it's a deferred or a straight probation and the term extension.
Okay. So what I think I'm gonna do, there's really no non-binding recommendation being made, is there? This is all.
Right, it's just, this is just.
Okay, so I'm gonna take the following binding. We'll check out community supervision. Did y'all agree on a term of years on probation, or is that my call?
That's your call, Chief Judge.
Okay.
Here's where it gets interesting. The judge mentions that probation can be shortened to 1/3 if she does well. That means a 10-year probation could become just 3.3 years with good behavior. But catch this. By accepting this plea deal, she's giving up all rights to appeal. That's a massive gamble. She's essentially betting her entire future on this judge's decision and her ability to stay out of trouble. Would you take that deal? Remember, she's already shown good faith by paying back $25,000. Let's see if that influences the judge's thinking.
I'm gonna put up to 10 is what.
Yes, sir.
Okay, is that your understanding of the plan?
Yes, sir.
If I follow this agreement of probation, deferred or regular probation, and order restitution, and this can be up to 10 years in length, it's the court's call, but whatever term of probation the court assesses, it can be shortened to 1/3 if you do well and complete probation. So 10 gets you 3 1/3
Yes, sir.
if you do well. You're going to do well.
Absolutely.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document? Understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. I think we need a pre-sentence report. So everybody can.
The judge just ordered a pre-sentence investigation report. This is huge. This report will dig into every aspect of her life: criminal history, employment, family situation, and most importantly, her ability to pay restitution. The probation officer's recommendation could literally make or break her case. Notice how the judge emphasizes the difference between deferred and regular probation again. He's clearly wrestling with this decision. The fact that he's taking time to gather more information instead of deciding immediately shows he's taking this seriously.
Everybody can then sound in, and because deferred, regular probation, one's got a conviction, one's not, and it depends on factors and circumstances that
Yes,
I don't know about.
Yes, sir.
Yeah, okay, what we'll do is we're going to order a pre-sentence report. You will touch base with the probation officer here in a minute, and you will come, they will interview you, and they will make a report. We will return back on.
We're gonna tentatively set for September the 26th, Judge.
September 26th.
Everything.
Missing your phone?
Yeah. All right, don't draw on.
Maybe that chair left.
I called China away a little bit.
Correct.
You said September 26th.
Another Friday.
Yeah, I can. I was sure I gotta be in Tampa on this that case that week, but it's the beginning of the week.
So that's good.
Yeah, it's good.
All right, we will return, then you will get a copy here. And then all parties can add any additional information you want me to consider, and the court will be fair.
Yes, sir.
And this is all fixable. And look, I'll tell.
Listen to this judge's tone. This is all fixable. That's not what you typically hear in felony cases. He's essentially coaching her on how to get the best outcome. And here's the kicker. Her attorney reveals she's already paid back over $25,000 of the roughly $89,000 owed. That's nearly 30% already returned. The judge's comment about victims not getting interest is fascinating. He actually thinks that's unfair to the victims, but he's still showing remarkable empathy toward the defendant. This judge clearly believes in rehabilitation over punishment.
When it comes to restitution, you pay the restitution back, you're going to get rewarded.
Judge, out of what she's taken, she's already paid back over $25,000 of the restitution that she
You
owed.
pay it
So the remaining.
complete, and the quicker you do it, the more happy I am about taking care of this, because the people aren't getting interest on it. They've lost, they're not getting interest, which isn't, I think that's unfair, actually. But the quicker you get them paid back, the quicker they can use the money that was lost, and that you get rewarded for that. Okay, just a little word to the wise, but restitution is a key part of this case. Okay, awesome.
Thank you.
Thank you.
So here's what just went down. Ladonna Lewis pled guilty to misappropriating between $30,000 and $150,000 in funds she was entrusted with. Instead of facing 2 to 10 years in prison, she's looking at probation, but the type and length are still up in the air. The judge will decide between deferred probation, which could clear her record, or straight probation conviction stays, after reviewing a pre-sentence report. With $25,000 already repaid and about $64,000 still owed, her commitment to restitution will be crucial. This case perfectly illustrates how the justice system can balance punishment with rehabilitation, especially when defendants show genuine effort to make things right. The judge's emphasis on quick restitution as a path to redemption shows that sometimes actions speak louder than apologies in courtroom. If you found this legal breakdown as fascinating as we did, make sure to hit that like button. Share your thoughts in the comments. Do you think she deserves deferred probation? And don't forget to subscribe for more jaw-dropping courtroom breakdowns where we decode the complexities of the justice system.